Yes, I salute you all. Thanks for watching and thanks for listening. Subscribe to the channel, like the videos. So basically today, I'm here with a colleague and he's here with us. We are going to take you through foundations of law, which at times is called the introduction to law, basically. And by name, Nyam Matalo Simon Peter.
By names of Counsel Mugisha, and we are taking you through the sources of law under the foundations of law, or call it introduction to laws. And my colleague is going to first take you through the primary sources of law in Uganda. Proceed.
Yeah, thank you very much. Me, I will take you through the primary sources of law, and these are some of the primary sources of law. Primarily, actually, what is a source of law? In case you don't know that what is a source of law, or as you are coming to tackle such questions, you first define what law is. You get? We have certain scholars. We have John Austin, who define law that is a command from the sovereign accompanied by the what? By sanctions, basically. You can use St. Thomas Aquinas, Marcus Tullius Cicero. You can use any scholar to define what law is. So basically, and the source of law, this is where law deprives its existence. Basically, the first source that I'll talk about under primary sources is the 1995 Constitution. This one must be on your fingertips, that while you're talking about the sources of law, the Constitution comes first, because it supersedes, it is the grand norm, it is the genesis of all laws in Uganda. And we shall refer to Article 2 of the Constitution that provides for its primacy, that the Constitution is the supreme law of the land. Any law that is inconsistent is null and what? And void, basically. We have seen different cases where certain laws are being repealed because they are inconsistent with the Constitution. There's a case of Salvatore Abuchi versus Anthony General. You can relate, basically. The Constitutional Court repealed the Witchcraft Act because it was against the right to property, it was against the right to movement, it was against many things, basically, that case, basically. So they repealed the Witchcraft Act. You get? We have the case of Charles Onyang Obo and Andrew Mwenda versus Anthony General. Yes, subscribe, press the subscribe button, press the notification button, and stay tuned and get all updates about this channel. Subscribe to the channel and like the videos. Where in the Penal Code Act they repealed the offense of sedition. Reason being, it was against Article 29, which was the freedom of expression, basically. So in this essence, they say that it was inconsistent with the provision of the what? Of the Constitution. We have the Uganda Females Lawyers Association versus Anthony General, where the certain sections in the Divorce Act were repealed because we are against Article 21 of the Constitution that provided for equality. You get?
Gender equality.
Yes, gender equality. So they repealed those sections in the Divorce Act because they favored the male gender at the expense of the female
gender.
Yes. So basically, those are the cases that can back up that the first source, which is the Constitution. So the other source under primary, we have the legislation. Legislation, you have two concepts. You have the principal legislation and the subsidiary legislation. The principal legislation under Article 79, Clause 1 of the Constitution provides that the Parliament shall make laws, basically. So that is the principal legislation. These are laws that are made by Parliament. And the examples of laws, we can look at acts, statutes, decrees. Basically, we have decrees, we have acts, we have statutes. Basically, these are some of the examples of laws that are made by the what? By Parliament. So that is the principal legislation that we are talking about. Okay. And you also have the case of the Uganda Law Society versus Anthony General. There's where the judge, it was an obiter dicta, whereby the judge said that it was Parliament to make laws, or it is only Parliament to do what? To make laws. Then when you go to subsidiary legislation, subsidiary, its existence comes from Article 79, Clause 2 of the Constitution. Article 79, Clause 2 provides that Parliament will delegate other bodies to make laws. For example, the local government and other bodies, basically. You get. And some of the subsidiary laws that we have bylaws that are made on the village level. We have ordinances that are made on the district level. We have rules and regulations that are made by the City Council, Kampala, KCCA, among others. We have orders that are made by various entities. We have notices that are made by different corporations. For example, we received the Bank of Uganda notice was it of 2002 basically. So that notice, it is also a subsidiary legislation basically. So in this essence, what you have to know, those are the examples of subsidiary, and the emphasis comes from Article 79 Clause 2 of the Constitution, where Parliament grants other bodies to make what? To make laws. So those are the two primary sources so far that we have looked at, the Constitution and legislation. Then the third one, we shall look at customary law. You get all the customs basically. This is also another source of law basically. And what you have to bear in mind, or what you have to put in mind, that in this essence, customary law is being applicable. When you see the genesis, I know you are studying constitutional law, the genesis of customary law under the Repugnancy Clause of the 1902 Order in Council. They say that any custom that was inconsistent in the British laws was null and void. It was witnessed in the case of Ara versus Amukeyo, where they say that customary marriage was just a mere wife purchase. But the concept was changed in the case of Alai versus Uganda. The concept was changed basically. So customary marriages are being what? Are being evident as a result. Because we have the case of Bruno Chiuwa versus Namazi and Ivan Serunkuma. You get the case of Bruno Chiuwa versus Juliet Namazi and Ivan Serunkuma. The dad to the wife was Bruno Chiuwa, they declare the marriage what? Void. Because it was inconsistent with the Ndiga clan. Because Namazi and Ivan were coming from the same clan, which was Ndiga clan. And what court said that a person has the right to promote his culture. I think it is under Article 37, if I'm not mistaken, that you have the right to promote your culture, basically. So in this essence, the marriage was declared a nullity because it was inconsistent with the norms or the culture of the Ndiga clan under the Waganda. You get? And also customary, when you look at the Judicature Act, Section 15 of the Judicature Act, provides that customary law will be applicable as a result. Yeah, Section 15 of the Judicature Act. Customary law will be what? Applicable in the laws of what? Judicature as a result. So that is customary law. So another primary source that we have equity and common land equity. That is another source. And the common land equity, someone may ask what is common law and what is equity. Common law, that was unwritten law, basically.
From England.
Yeah, from England. And equity, these are rules of fairness and justice, basically. That is equity. So in this essence, common law and equity, they move together. I know this is a bit, but you will appreciate the course unit in front there as you move further in your studies. So under common law, this was unwritten law and it was not written anywhere. And we received such law through the reception clause under the 1902 order in what? In council. That's when we received the common law and what? And the equity as a result. So the example that of common law that is unwritten, I may say that, for example, there's a concept that we study under contract, which is invitation to treat. It is not written anywhere. So it is just a common law. And we have seen equity. Equity, some of the maxims in equity, where two equities are equal, the first one in time prevails. Equity shall not suffer wrong. And basically, they say that equity looks at substance rather than the form. Delay defeats equality. Delay defeats equity. So there are a lot of maxims, but those are the few that I can talk about. There are many other maxims, but to suit your discussion, you bring out such maxims. And the authorities, when you look at Section 11 of the Magistrate Court Act, provides for that both equity and common law shall be applied what? Concurrently. That is Section 11 of the Magistrate Court Act. Then when you also look at Section 14 of the Judicature Act, also provides for the same, that both equity and common law shall be applied what? Concurrently. What does it imply, or what does it show? It shows that the application of equity is being evident in our courts. So equity and common law becomes now a source of what? A source of law. Where there is fairness, where courts see that there is need of fairness, they'll apply equity. You get, so that is the point. So we have looked at equity and common law, then we go to precedents. Precedents can mean as case law, basically, as also another source of what? Another source of, a primary source of law. And precedents, these are decided cases that are binding. You get, however much we shall see the chronological order, we have persuasive, we have binding,
persuasive and
binding precedents, basically. But that is also, don't engage so much deep, but we just know you have binding and persuasive what? Precedents. And such precedents, let me give an example. There's a case of Donnock versus Stevenson. This case laid a precedent, basically. It brought in the neighborhood principle under the law of negligence. That is the case of Donnock versus Stevenson. And also you studied the case of Khalid versus Carbolic Smoke Ball Company. Under this case, they held that in this essence, an invitation to treat, they brought out the concept of invitation to treat. But it brought out the concept that where an offer can be made to the entire what? World, basically. You get? So that is the case of Khalid versus what? Khalid versus Carbolic Smoke Ball what? Company. There's a lot of cases. We have the case of DTB versus Ham, the case of Ham versus DTB and others. That case whereby the court held that syndicate banking is now illegal in what? In Uganda. So such cases are precedents. They are normally binding to the lower courts. Such principle that is laid there is a precedent to the rest. We have the case of Kabaziruka, that recent decided case that was decided in in the Supreme Court, Kabaziruka versus Anthony General, where they held that the court martials were just mere disciplinary committees, whereby civilians couldn't be tried in what? Court martials. So that is also precedent as a result. So among other cases, there are a lot of cases. So I think those are the primary sources. Maybe I've forgotten any, but I think those are the primary sources.
Yeah, those are the 4 primary sources of law under the foundations of law. We have looked at the Constitution, which is the what? Supremacy law in Uganda, and all laws are codified from the what? From the Constitution, whereby any provision from the statute that shall be contrary to the provision of the what? Of the Constitution shall be what? Considered null and void. And also we looked at what? Case law. We have looked at also what? Case law, you can also define it as what? Precedents. So we have also looked at the Parliament, whereby that is the legislature, whereby under Article 79 of the Constitution, Parliament has powers to do what? To make laws. And under legislature, you also have what? Subsidiary law and what? Principal law.
Yeah.
So
from and also equity and common law.
Equity and common law.
And customary law.
And also council cited out somewhat maxims to do what? Like for example, what? Equity shall not what?
Suffer wrong.
Without what?
Without a remedy.
Without a remedy. So from that, we are going to look at the secondary sources of law. When we look at the secondary sources of law, we shall briefly just explain them. We'll give out an example, and then we call it what? A day. So the first secondary source of law, we have textbooks. What is the instance of textbooks? The textbooks shall what? They do what? In general, they explain the legal objects and also give us somewhat explanation towards the principles of law. For example, you look at the Introduction to Laws by Kidu Makubuya. It also what? It is also an example of what? A textbook. You look at other textbooks under company law, what? So also those what examples of what secondary sources of law. We have also law journals and article. For example, you look at Makelele Law Journal, you look at the Law Journal of LODC. There are also what good examples of what of secondary sources of law. From that, we look at the publications from law reform bodies. We have Uganda Law Reform Committee and also what JIROS. They are also good sources of what laws in Uganda. Then another source of law, we have the dictionaries. Under the dictionary, we have the Black's Law Dictionary. Black's Law Dictionary, as you see in some cases, we see judges that they be citing out the Black's Law Dictionary. We get definitions from the Black's Law Dictionary, meaning is also a valid secondary source of law. Other than the Black's Law Dictionary, we also have the Osborne's Dictionary. It's also an example of secondary source of law. So briefly, those are the secondary sources of law. In case counsel, you have another source, you can give it out.
Yeah, basically there are other secondary sources. You have encyclopedias. There are also secondary sources of law. We have international treaties. International treaties. We have law conferences. There are also treaties. We have articles. You know, there is a difference between textbook and an article. There are those articles that are written by certain scholars, you get, in law, basically. So articles, they can also be secondary sources of law. We have also parliamentary sessions, basically, more so done with the legal committees or the legal reforms in parliament. Those meetings or the minutes taken, they can also be as secondary sources of law. We also have I think basically those ones could be the ones. Basically those could be the. We also have however much this is more of under when you look at legal research. Legal research. We also have what they call indexes. Indexes as also secondary sources of law, basically. So those are the few that I can highlight under the secondary sources of law.
So basically, when you come across a question that is asking for the sources of law, you have to start with defining what law is. You define the law, you can define it according to any scholar, as counsel said, or you define it according to the Black's Law Dictionary, because it's also a source of law. Then after that, you have to go to the principle, or what we call the primary sources of law, without forgetting the Constitution, without forgetting the precedents, equity, and also case law. So after that, you go to the secondary sources of law, list them, explain them, give an example. For example, the dictionary, give the Black's Law Dictionary, give the Osborne Dictionary. Then after that, you conclude. Thanks for watching and thanks for subscribing.
Wish you well. Yes, thank you for watching. Thank you for being on the channel. Subscribe to the channel, like the videos, share the videos, and stay on. Thank you very much for always watching. Stay blessed and be blessed. Continue watching.